Bandyopadhyay, I think you should go to the issue of section 165.
I am coming.
Other issues, Madan Lal, participation, everything has been placed before us.
Everything has gone. Very important. That is, but somewhere CBI has been referred in the judgment. Please, CBI has been referred. CBI. What the CBI is there? What are the materials were there before the land signature? Nothing was there. No pleadings, nothing. No materials.
Yes.
No pleadings, nothing. Let's assume, Millard, there's a report. Let's assume for the timing. Let's assume for the timing. There's a report. Any report is there. What is that evidentiary value of that? Report we have not seen. We have not got any chance to deal with the report. CBI has been said. Let's assume, for argument's sake.
Yes.
My lord, how far it is valid? How far, whether it has any evidentiary value? A report itself. On which basis some perception has come into the mind of any judges?
Yes.
Kindly take me, Lord, 2022-12 SCC page 200. Your lordships will get it in my compilation at page 360.
344.
344. 344. Cases below Rajesh Jadhav versus State of UP.
Yeah, this was placed.
My lord?
Yes.
Paragraph 363, your lordships come.
Para 27.
Yeta bar korto, ye judgment talukdar.
Para 27.
27. আমাকে একটু কাজটা করতে দিন সেকশন 173 subsection 2 paragraph 27. Section 173 subsection 2 CRPC calls upon the investigating officer to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer. My lord, got it?
Paragraph 17 you have to see.
Paragraph 27, my lord, at page 363.
363.
3.
Yes.
Section 173 to CRPC calls upon the investigating officer to file his final report before the court. It being a report is nothing but a piece of evidence. It forms a mere opinion of the investigating officer on the materials collected by him. He takes note of the offense and thereafter conducts an investigation to identify the offender, the truth of which can only be decided by the court. The aforesaid conclusion would lead to the position that the evidence of the investigation is not indispensable. The evidence is required for corroboration and contradiction of the other material witness, as he is the one who links and presents them before the court. Even assuming that the investigating officer has not deposed with so and so, has not convinced so and so, not entitled for acquittal so. An opinion can be the basis of my termination of service, which has not been proved, which has not been relied upon by the petitioner in his pleadings. No report has been relied by the learned single judge. CBI, as if CBI is a god and nothing has to be required to be done. Even the report is not there. It has to be proved, my lord. Is there any single allegation against any of my clients that he has committed this criminal offense? Kindly take it, my lord. The proceeding is continuing for years. Any of my client has been called as a witness, investigated, arrested, nothing. Termination of because of any perception. In a court of law, it has to be proved.
Yes.
But second one also, kindly see. MC Mehta. Taj Corridor matter.
Mehta.
MC Mehta versus Union of India. This Taj Corridor scam. 2007 1 SCC. Page 110, paragraph 27. At page 372 of compilation. At 390. One paragraph I will just read below. You- 165 corporate dark detail.
Yes.
That's not applicable. बोले तो पैसा What is it? Can I read Millet?
Yes.
Paragraph 27. See, in K. Virasamy versus Union of India, this court observed with paragraph 17 as follows. The charge sheet is nothing but a final report of a police officer under section 173(2) of the Criminal Procedure Code. Section 173, subsection 2 provides that on completion of the investigation, the police officer investigating into a cognizable offence has submit a report. The report must be in the form prescribed by the so-and-so, the nature of the investigation, the names of the person so-and-so, A, B, C, D, E, F, G. Then as observed by this court in Sotonaran Musal so-and-so, that the statutory requirement of the report under section 173(2) would be complied if the various details and so-and-so are included. This report is an intimation to the magistrate that upon investigation into cognizable offence, the investigating officer has been able to procure sufficient evidence for the court to inquire into the offence and necessary information is being sent to. In fact, the report under section so purports to be an opinion of the investigation, that is, as far as he is concerned, he has been able to procure sufficient material for the trial of this so-and-so. The report is complete if it is accompanied to all this so-and-so. Nothing more need to be said in the report of the officer. It is also not all the details of the officers must state. Therefore, what is that? It is an opinion. Opinion is not a final thing. For that reason, my service have to be terminated. Even the charge sheets which have been filed, not a single one of my clients has been made an accused.
Yes.
My lord, your lordship was asking me for Assi Baba. Asking me, my lord, what about the 165 of the Indian Evidence Act? 165 of the Indian Evidence Act.
That
First-
has been extensively argued by Mr. Dotto.
But your lordship was asking.
Yes, that what is your
My lord, I hope Mr. Dotto has not submitted that which I have submitted. If you invoke 165, I should get the chance to cross-examine.
yes. He has argued that.
He has argued. I have also argued. Then, my lord, whether Justice Subrata Taluka's judgment has been placed.
This September judgment which you showed us,
No, no.
the
I'm
judgment
showing-
against which you preferred the selfie,
Can you take this?
the first one.
Now, dealing with 165. Dealing with
Show
165.
us, show us.
আপনার জন্য
Or judges will-
জজের জন্য আছে সাইটেশনটা পড়ে দিন
This is, my lord, 2022 SSC Online, Calcutta 3991.
This is which one, Mr. Bandhote?
Ramesh, West Bengal Board of Primary Education and others versus Ramesh Malik. This has been placed. I don't think. Just for 165.
পেজ নাম্বার
No, we haven't.
I am just referring the judgment only for 160. It's a big judgment, but I am relying only for the 165.
প্যারাগ্রাফ 10
This is in a different matter, no? Ramesh
Uh-huh.
Malik. Para 165.
No, para what?
6110
Para 61,
Acha.
subparagraph 10
and 11
and 11. At page
পেজ নাম্বারটা আছে এখানে
page 48. It's very small. It has been written at the top. Can I just make out for you? Let's find out at the top. It's
Page,
very little. Here,
yes.
page 48.
Yes.
Flag দিয়ে দিতে হতো।
Yes. 61.
Can you take my copy? I have flagged it.
61 subclause 10 you said.
Subclause 10, huh? It was-
Page 40. Yes, got it.
Similar. In connection with the above discussion, this court must now notice that the line of argument which has emerged from the learned counsel for the appellants.
Just.
My lord, got it?
Just.
Page 48. My lord, at
Page 48.
43. 40, huh?
48 ওটা
Okay, 48.
46
46, huh?
46.
Very small. Very small.
Yes. 10 in connection with
In
the
connection with the above discussion, this court must now notice that the line of argument which has emerged from the learned counsel for the appellants on the procedure of taking evidence by the honorable single bench applying section 165 of the Evidence Act. As discussed earlier in this judgment, learned counsel for the appellants have strenuously urged that evidence in the manner required to be taken under section 165 of the Evidence Act by a court has been not so done. The power of the court to take evidence under section 165 have been discussed in reference Ramchandra State of Haryana, so and so 813. What is the true role of the judge trying a criminal case? He has to assume the true role of a referee in a football match or an umpire in a cricket match. Occasionally, answering the Pollock and Maitland point out, the question how is that or easy to, in the words of Lord Canning, drop the mental of the judge and assume the role of an advocate. Is it to be
Yeah,
expected?
this was placed, I think. Anyway, you place.
Well, if it is placed, then I don't need to place.
81.3 SCC.
No, 81 CSCC may be placed by Mr. Dutta.
You are placing that extract of
Yeah,
81.
yes, yes.
Yes, anyway, you
Anyway, Mulad, this is I will not Mulad, disturb your Mulad. 81 since it is now kindly come to paragraph 11. Next paragraph. In the teeth of the above stated elucidation of the law, which albeit follows from the manner of conducting a criminal trial and may not be wholly apropos to writ proceeding, which are not controlled but guided by statutory procedure. At the same time, this court finds that summary application of section 165 by the honorable single judge to be offensive of statutory procedure and constitutional safeguards, while recognizing the jurisdiction of the honorable single judge to choose the manner of exercise of its prerogative jurisdiction. It requires no emphasis that justice must not only be done but also seen to be done. Next, on the issue of restrictions. Therefore, a coordinate bench also has taken this view, 165. And 165 other arguments I have made. And this is not known. I have in my entire career, I have done the evidence in the proceeding, Vikiri Paswan's case. And in the Vikiri Paswan's case, in a read proceeding, this Vikiri Paswan, that time public interest litigation was not there. And it was in 1992, 1993. What has been done? In Vikiri Paswan case, the judges have not called the witness. Come here, put the questions. The then Advocate General was against me. First witness was led by the then Advocate General Norman Gupta, which I have cross-examined by. The other witnesses have documentary evidences were placed. Parties have got the exhaustive opportunity to examine and cross-examine. It is not that the writ court cannot take an evidence. I am not saying so. In an extreme cases of liberty. It was habeas corpus matter. I tell you, if I remember the day in 1993, my leader was Mr. Gunnar Sen.
Yes.
When the case diary was produced, the entire file was given. And it was a bench presided over by Justice Subhash Sen in courtroom number 19.
Yes.
The entire case diary was given to us. Mr. Sen, my leader, was cross-examining the witnesses. I was thorough. Very quickly was going to the records, and one record I have shown to my senior. Senior has placed that to the senior the judges. Judges have stopped the evidence. Direct CBI. The document itself says that yes, the matter needs a deeper investigation. And it is a case of a murder written by the DI. I have seen that without evidence, examination of evidence.
Yes.
There are so many lawyers are there. They have also seen the evidences in their respective cases, but not in this way. The judge will call. Yes, tell me what is this questions and answers. Just give me the questions and answers. The judges may have been made.
Yes.
Judge is making questions one after another.
We have seen that.
Therefore, whether the judge had the role of the prosecutor or the judge.
Yes. That we have seen. That has been argued also before us.
Anyway, just I am reminding to us.
Yes.
There was a judge. A judge cannot be prosecutor of his own case. He should judge. Anyway, I'm not going. This is the way. Evidence are given to you know. All questions have been raised by the judge. Was it a proper procedure followed under section 165 of the Evidence Act?
Proper procedure meaning what was the procedure?
165 procedure, see the procedure.
That is up to the discretion of the judge concerned.
Discretion. Evidence may be called, evidence may is a discretion,
Hmm.
but judge will not be a prosecutor.
No, that is separate. Judge will not be the
But
prosecutor.
discretion, if you exercise the discretion, you have to give reasons.
Yes, yes.
But there
It
is
was put by the judge, na? You are there. Oh, if anybody of you might be. Huh? Where is Mr. Tiwari?
Questions of
Anyway,
judge.
it was put by the
no,
by-
the losses have seen the questions have been
Yes,
put by the all the questions. And thereafter, board has been asked to cross-examine, board did not cross-examine.
who did not cross-examine?
Board. As per
Yes, yes,
records.
board said we had didn't we were not given the opportunity also.
What?
That was we were not given the opportunity.
That's all right. Very good, board, if this is case. Then today, what would be done? If this evidence, your lordships, if he affords the judgment, reject our case, then on the basis of the reasoning, and one of the reason of the evidence, let's go and see the judgment now. Examine. Now judgment. And last I will few cases that the law will prevail over the equity. I will show that and I will finish. Kindly come to the judgment. I don't know where from your lordships have read. Can I take my copy pillar page 551?
বোর্ডের পেপার বুক থেকে পড়েছেন আমি মার্ক করেছি পেজ নাম্বার
Oh,
Okay.
73.
Go.
Yes, yes.
Now judgment 610.
ইন্টারনাল পেজ রেফার করলে
Internal page 2, internal page 1, 2. Kindly come to internal page 3.
জাজমেন্টে
Judgment. My lord, got it? Judgment?
Yeah, just. Yes.
Kindly come to paragraph 5. First, see paragraph 4. When the petition filed the petitioner, they wanted the authorities to file a report disclosing names, numbers, rank, category, etc. of the non-trained candidates who have been recruited by the board from 2014, including the date of recruitment, and to treat the petitioner equally with the non-trained candidate. This was the scope of the petition. Now, similar paragraph 5. During the course of hearing, the petitioner disclosed various particulars collected from publications made by the board in the website showing that there were serious illegalities. Why this? Why it has been disclosed? Such a vague
Yes.
lines will decide my career. Made by the board in the website showing that there are serious illegalities in preparation so and so process when viewed in respect of the untrained candidate at the time of recruitment and while disclosing such particulars. They made it clear that all their allegations of illegality in recruitment are in respect of untrained candidates at the time of recruitment who are given appointments to a recruitment program. At the same time, they made clear they do not have any grievance in respect of the trained candidates who are responsible and given appointment in the recruitment. Therefore, the candidates who are trained at the time of recruitment outside the scope of the petitioner paid for filing supplementary affidavit which was granted, and from the supplementary to the retrieve, it became evident that all the petitioners are qualified to and participated in the 2016 recruitment process, and they are called in the job but did not get the job. The court directed the board to file one report as to so and so. Then paragraph 7. From this said backdrop, the party petitioners found and alleged that the particulars given there are absolutely false, as because the lowest number of impaneled candidates was shown in the report as 14.191, whereas throughout the West Bengal, 82 candidates below 13 were appointed, and the petitioners prepared a tabular sheet. Before the learned single judge, no affidavit was filed to this extent. Kindly mark this one, this paragraph. Whole West Bengal has written. The learned single judge has taken note of the whole West Bengal, but it was district-wise selection. It was a district-wise selection. Suppose in one district, the lowest one has got 13. Suppose in Kuchbihar district 13, district-wise selection he has selected, and in Purulia district he is 15. He may not get it. And you have taken Purulia district is compared with Kuchbiar district is compared with Hobson's choice.
Yes.
Justice is not a one-way traffic, justice is a double-way traffic.
Yes, come to the next. Which paragraph you want?
That's it. I mean, why I'm reading one after. Therefore, this is wrong. When I was pressing to your lordship every time, I have from district-wise. I marked it to your lordship. Now, district-wise selection. He has gone to the West Bengal-wise selection. How it can be? Suffers from illegalities. Then come. Who below are appointed by this one, so such exception filed in the form of the. Now, my lord, kindly your lordships will find, my lord, Rule 8, Sub-Rule 5 of the West Bengal Primary School Teacher Recruitment Rules 2000, page 108, volume 1 of my paper book, that speaks about district-wise selection.
Council wise.
That speaks about district-wise selection.
What is that?
My lord,
What you are saying? This.
this is, my lord, Rule 8, Sub-Rule 5 of West Bengal. Kindly lordships take, my lord,
No, you,
page 108 of volume 1 of my
no,
my paper book.
You read it, Mr.
I'm reading.
108 একটা 13 তে আছে ওটা
My lord, 113,
85
85.
That has been.
কাউন্সিল ওয়াইজ মানে ডিস্ট্রিক্ট প্রাইমারি স্কুল কাউন্সিল ওয়াইজ ডিপিএস প্রত্যেকটা ডিস্ট্রিক্ট
Yes, 113.
Then we let's see page 113 lordships kindly come. Rule 8 sub-rule 5. 8 sub-rule 5. 113.
Yes.
This selection committee shall prepare separate council-wise panel. Council-wise panel? My district primary school council.
Yes.
How can you compare Purulia district with the Kuchbiar district? Jalpaiguri district with the Bankura district? Next page. Paragraph 8, kindly see. From the pleadings of the pleading, found they wanted marks of last time panel candidate of different categories like SC, ST, but no such particulars are supplied and produced by the board despite detection given. In the affidavit of the board maintained silence in this regard. How they wanted marks of last time panel is a information center, is the High Court will be turning into. Then made the application and the Right to Information Act. And court will direct that you give the information, the Right to Information Act has to be annulled. Then we let paragraph 9. In respect of holding aptitude tests, the chairman of the board in his report said the aptitude tests were taken, but from the evidence adduced by the interviewers and the candidate is proved before there no aptitude test was taken. Give me chance to cross-examine. Send it back to the learned single judge. He has given 556 names are there. Unknown procedure of law has been followed.
Yes.
Page 56, 557. Then kindly come to page 559.
Paragraph
10. Why marks is illegal? Because interview evidences were there. Kindly come to paragraph 10. Therefore, the marks given to the candidate against aptitude test is wholly illegal and false exercise to who do it all concern, including the court. Because of paragraph 9, paragraph 10. Because of invocation of 165 by the single judge without affording any opportunity. Then because of paragraph 9, the 10 finding is there. If 9 goes, how 10 remains? Either your lordship has to say whatever the correct procedure has been followed by the single judge. No requirement of the cross-examination by any party. Whatever the judge will ask, judge will then take the role of the prosecutor and things. Otherwise, judgment is required to be set aside. Then come paragraph 11. The board has not given any reply in respect of awarding 9.10 and 10 marks to a large number of candidates. Can this question be raised by the court? I hope, Lord, lordships can remember, Lord, I have argued this point in 2 or 3 occasions that Sadananda Doloi's case. Before the lordships, Lord, right from that, shall I cite the judgment? I don't think it is required. Can you go in a microscopic evaluation? Can you be a fact-finding authority for a selection process? Therefore, these findings in paragraph 11 is contrary to the law laid down in the Sadananda Dole Halo's case. read with my lord, two judgments of my lord Justice Chakraborty. I will give that one later. One in the civil, and also in the recent that senior primary teachers.
Mr. Bandyopadhyay, please kindly come paragraph 16.
16. Okay. Yes. Few of the cases have been there. They have been marked 9.5, 10, 10.
No, 16. Internal page,
Oh, sorry,
paragraph
16. I'm sorry. 16. Though the relevant rule 7 of recruitment rules of 2000 mandates constitution of selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment teacher. It was done by one outside agency. It was not done.
Please.
A third party which is not at a part of the board, and this party was named as confidence secretary of the board. This is clear violation of the recruitment rules.
What is your answer?
Well, this is, I hope Mr. Advocate General has given the answer to this.
আগের দিন যে কোশ্চেন করেছিলেন
হ্যাঁ।
বলেছি আমরা দেব
Well, this answer will be given by the board.
ঠিক আছে স্যার
এখনই বললেন? This answer will be given by
We
the
will
board.
take it from Mr. Sodhi.
Because I can't say, my lord, this is. See, my lord, kindly see from my angle.
Yes, we have seen it.
Only no.
You are not parties, you are.
No.
Yes, we have.
You have seen me on the, one after another, my lord, in a facet. See another facet of me. Right? See, and it is and always love, my lord, I always love that smiling of your love from this
Yes.
side or that side.
Yes, Mr.
Now, my lord, see, am I responsible?
You were there in paragraph 15, Mr. Bandyopadhyay.
Paragraph?
15. You are
15.
placing paragraph 1.5.
Yes. No, I'm look into the entire thing. Very, what a wrong I have committed. Let's assume, my lord, this has been done. Let's assume. Am I responsible? Whom I will be called in an interview. I have gone there. And after 10 years, my service will be terminated. Am I responsible? Kindly look also from our angle also. Some CBI, something has been given. Does not know that. Is there any finding? Any of us has been arrested? What is saying? An unfortunate country of us, that if some persons have committed any offense, you have arrested and you have not finished the trial. Now, I was reading that paragraph 15. Just I will very 15. The board has not given any. So far the 14 is concerned. My answer is that's further on those cases, etc. And how many cases have been given example? Hardly 25 or 30.
1,20,000.
Huh?
For setting aside 36,000.
Huh?
Yes.
A total candidate was 1,22,000 at that point of time. Out of 1,22,000, you have found out a few cases. In Bengali it says na, ukun bachar moto kore bachbo. And without any affidavit, without anything. That's further on this case, Lord, kindly remember, I am not pressing it. My Lord Justice Chakraborty, I am not pressing this. Pressing means relying, not reading. All the judgments which have been referred in my notes, all the judgments are being relied.
Yes, we understand.
Paragraph 17. Then from the gross illegality in the selection procedure in the recruitment exercise 2006 conducted by the board, it is clear that the board in its official, including its former president, who is now in custody after arrest by the department for the transaction of used money in the recruitment process conducted by the whole affair like affair of a local club. What is this language? Your lordships will say something to me. This is a language of a
Yes.
judge of the court, high court. Your lordships will scold me. But you see what is the language? Local club, and now it is gradually coming to light over enforcement director and jobs for primary school teachers were actually sold to some candidates who had got the money to purchase. Where is this findings? Finding of facts. You are saying this without any evidence, without anything. A court will say. I can understand it is not a discussion in the TV channel after 7 o'clock.
Yes.
What is the evidence? What is the findings in the judgment? Why you have shown? Not based on any evidence. A corruption of the magnitude was never known in the state of West Bengal. He is not a philosopher or a politician. The former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars of the CBI. Is it a relevant finding? Is it a relevant finding? But if this is the ground for termination of my service, this allegation should be proved. Rather, my lord, I put it in another way, they should have proved these persons have taken money from me. And I have been arrested. Nothing is there. Everything is in air. Nothing is here. Everything is on air.
Yes.
My lord Justice Mitro, it's all right.
Yes.
Now, paragraph 18.
That you have said. That you have.
Niceties. More I will not say.
Now you can conclude.
My lord, almost my lord, on 43 years, now I'm 44 years practice. I have always tried to find out the niceties of the law. And I love the law in that way. And I say this profession, this is my passion, it is my preference in life. All the time I love after the niceties of law. And here in a case, the learned single judge is saying no niceties of law.